In 1965, Congress passed the Voting Rights Act, the most consequential federal legislation to deal with voting since the end of Reconstruction. The act was sweeping in its goal of enforcing the 15th Amendment and protecting the voting rights of African Americans in the South. The law outlawed literacy tests and extended the ban on poll taxes to state and local elections. It gave individuals who faced discrimination in voting the right to sue in federal courts to protect their voting rights. The Voting Rights Act also created criminal penalties for anyone who attempted to bar someone from voting based on their race. The act also gave the federal government the right to oversee elections in places where accusations of discrimination were made or in places where historical discrimination was obvious. And most sweepingly, Section 5 of the Voting Rights Act gave the Department of Justice the power to preemptively block changes in election laws if it felt that those laws or rules would create a discriminatory environment. The so-called preclearance power was the strongest tool ever created by the federal government to root out discrimination in elections. The Voting Rights Act of 1965 was a triumph for American democracy, and it has remained one for more than a half a century. Yet today, it is being challenged and weakened. Hi, I'm Evan Bennett, and I'm Professor of History at Florida Atlantic University and Director of the Voting Rights History Civic Literacy Project. And I'm here with 3 things you need to know about the 1965 Voting Rights Act. 1. It was the product of a long struggle to secure voting rights for African Americans in the South. But it was the civil rights movement of the 1950s and 1960s that set the stage for its passage. African Americans had largely been denied the right to vote since the end of the 19th century, despite the clear language of the 15th Amendment that no one could be barred from voting based on race. By the 1940s, however, African Americans had begun to chip away at the legal framework that had denied them meaningful access to the ballot. The 1944 Smith versus Allwright case had been a major victory in striking down the white primary. But in the 1950s, Southern states redoubled their efforts to keep African Americans from the polls. Several Deep South states held on tightly to the poll tax. Others reinforced their literacy test requirements. Louisiana's infamous Understanding Clause, which had been created in 1921, was used to create new tests that made it possible for voter registrars to deny the vote to almost anyone. When legal fraud would not work, Southern political leaders turned to violence. In the years following World War II, violence against African Americans who sought the right to vote increased greatly. In some places, newspapers would publish the names and addresses of those who tried to register to vote. Those listed often lost their jobs, their homes, and sometimes even their lives. Mississippi and Alabama stood out for their notorious treatment of black voters.
I'm Mrs. Fannie Lou Hamer, and I farmed on the Marlowe plantation for 18 years. I had charge of keeping up with the time and paying off, and I went down the 31st of August to try to register. And after I had gotten back home, Mr. Marlowe told me that I would have to go down and withdraw my registration or leave because they wasn't ready for that in Mississippi. And I said, Mr. Marlowe, I'm trying to register for myself. So I had to leave that same night after I had gone down in August. And then I spent one night with Mrs. Tucker, and after about 2 days in September, they shot in the house 15 times thinking that I was there.
In Mississippi, civil rights workers engaged in 1964's Freedom Summer found themselves imprisoned, beaten, and harassed for trying to register people to vote. Despite the passage of the Civil Rights Act in July of 1964, they were able to make little headway in challenging Jim Crow, particularly at the polls. They created the Mississippi Freedom Democratic Party as a shadow organization to the state's all-white Democratic Party. They did this to highlight the extent of their disfranchisement. When they challenged the state Democratic Party's legitimacy at the National Party's convention in Atlantic City in 1964, the National Party, including President Lyndon Johnson, refused to seat them. While Johnson had supported and signed the Civil Rights Act earlier that year, he was unwilling at that point to take up the issue of voting. Events in Selma, Alabama, beginning in March 1965, changed his mind. In February 1965, activists with the Student Nonviolent Coordinating Committee, or SNCC, and ministers with the Southern Christian Leadership Conference, the SCLC, joined the Dallas County Voters League in order to challenge disfranchisement in Dallas County and Selma particularly. They chose Dallas County because despite the county's black majority population, only 2% of eligible black voters had been allowed to register to vote. On March 7, 1965, the protesters set out from Selma to march the 54 miles to the Capitol in Montgomery to demand their voting rights. They got no further than the Edmund Pettus Bridge just outside Selma, where they were met by sheriff's deputies and state troopers who beat them and tear gassed them. The beatings made international news and shocked millions of Americans. President Johnson publicly condemned the beatings and declared that it was time to end discrimination in voting. Every American citizen must have an equal right to vote, he said in a televised special address to Congress. There is no reason which can excuse the denial of that right. There is no duty which weighs more heavily on us than the duty we have to ensure that right. Johnson brought in federal resources, including U.S. Marshals, the Federal Bureau of Investigation, and the National Guard, to ensure that a second march on March 21st could be completed. He also pressed allies in Congress to pass the Voting Rights Act to enforce the 15th Amendment. It took months, but finally on August 6, 1965, President Johnson was able to sign the Voting Rights Act into law. Within a short time, black voters were able to register and vote in places that had worked very hard to keep them from the polls. It did not change the South overnight, but within a few years, black voters were able to participate across the South in larger numbers. Throughout the South, black candidates were able to win election to office at all levels of government. 2. The Voting Rights Act was expanded in later years to prevent other forms of discrimination. Some of the most important enforcement provisions of the 1965 Voting Rights Act were set to expire in 1970, which meant that the law needed to be extended. Some feared that a backlash of opposition might prevent it from being extended. But in fact, the law was expanded. Enforcement provisions were strengthened. The number of areas to which the law applied was expanded, and the ban on literacy tests was extended nationwide. Stringent residency requirements, which had disproportionately affected low-income voters, were now banned under the expansion of the law. These changes came about because it had become clear that discrimination against other voters, Latinos and Native Americans in particular, was widespread outside the South. In 1975, when the law came up for another renewal, it was strengthened yet again. Congress strengthened federal oversight of local election laws where historical discrimination could be proved, and it introduced protections for language minorities. Under the 1975 expansion, voting rules or laws that discriminated against those who did not speak English or had limited English proficiency were struck down. And not only that, the law required the printing of ballots and other official materials in languages other than English if speakers of those languages made up a certain percentage of the voters. In 1982, the Voting Rights Act was expanded yet again with what was known as the totality of circumstances standard that made it easier to prove discrimination. The courts no longer had to find that voting rules were intentionally discriminatory, only that in the totality of circumstances, they were effectively discriminatory. For voting rights activists, this was a major victory because they no longer had to prove that those creating discriminatory laws were doing it on purpose, only that the laws themselves had a discriminatory effect. With this power in their hands, activists were able to protect the voting rights of African Americans and other minoritized citizens. The spirit of the times, in fact, indicated a desire to expand voting rights as much as possible. The 1990 Americans with Disabilities Act, for example, included provisions that made it easier for the disabled to vote. In 2006, President George W. Bush signed a further extension of the Voting Rights Act, this time for 25 years. It had passed Congress with near unanimous votes in both houses. 3. Despite this support, the power of the Voting Rights Act has been restricted in recent years. The Voting Rights Act has always faced some opposition. In most cases, opposition came from the states it affected, particularly from those whose power it sought to constrain. However, beginning in the 1980s, some began to argue that many of its provisions were flawed. They particularly rejected interpretations of the law that affected the drawing of congressional and legislative districts that ensured minority participation. Under the 1982 totality of circumstances standard, voting rights advocates had successfully blocked attempts to dilute the voices of African Americans and other minority voters in districts drawn to ensure they would be well outnumbered. The courts had agreed that while their dilution might not be intentionally discriminatory, it had a discriminatory effect. As a solution, the courts agreed that districts that allowed minoritized voters to have a majority of voters in a district were preferable because it allowed them to have an effective voice in politics. Opponents of these so-called minority-majority districts, even some who had supported the Voting Rights Act, felt that this violated the spirit of democracy. By the 1990s, they had begun to amass legal arguments and political support for constraining the Voting Rights Act. Among the leading thinkers in this area was John Roberts, who George W. Bush appointed to be Chief Justice of the Supreme Court in 2005. And it has been the Roberts Court that has most effectively limited the Voting Rights Act in recent years. Beginning in 2010, numerous states began to pass voting legislation that challenged earlier interpretations of the Voting Rights Act. This included voter ID laws, voter registration policies, and early voting rules. The Justice Department struck down many of those laws using Section 5 of the Voting Rights Act, but some states and local governments sued. In 2013, the Supreme Court heard one of these cases, Shelby versus Holder. In the case, lawyers for Shelby County, Alabama, argued that Section 5 of the Voting Rights Act was unconstitutional because it held them to an unfair standard based on historical discrimination. The court agreed. In a 5-4 decision, the court struck down the formula for determining discrimination in Section 4 of the Voting Rights Act and struck down Section 5 entirely. The law was not struck down entirely. It's still illegal to discriminate against someone in voting, but now those who face discrimination must prove discrimination in court rather than having it struck down before it happens. This has given the courts an even greater role in elections, and it's likely that that will continue into the future. As for the Voting Rights Act, what's left of it remains law until 2031, when it comes up for a vote again. In any case, whatever happens will have significant consequences for American democracy.